Having an LLC as a form of asset protection is a very good first step in protecting your assets. However, it does not work in all contexts, and it does not work for all assets. And your primary residence is a perfect example of why an LLC is not the proper instrument to protect your residence. In this video, we are going to explain why an LLC is not the proper instrument for protecting your home. Greetings, my name is Phancao with the Asset Protection Center. I am an estate planning attorney focused in the field of asset protection and elder law out in the state of California and Florida. So let's get back to basics. An LLC, a limited liability company, is in essence an instrument for you to conduct a business. So without having to think on a legal plane, you can quickly realize that an LLC does not have to hold a primary residence in order to conduct a business. Despite that knowledge, I've seen too many practitioners encourage their clients to do so, and they do it under the philosophy that, hey, maybe it's a home business of some sort. So let me give you an example. Let's say that you actually run a legitimate business out of your garage. Well, the situation you would find yourself in is that that particular portion of the residence would be protected, and then you would be exposing the rest of the equity of the home. So is that an efficient tool in the context that I've just given you? Not at all. So I would not encourage you to do so. There are other disadvantages that come with putting your primary residence in an LLC, and there's quite a few of them, so hopefully I won't forget all of them. Let's start with the first one. Number one is the step up in basis. That is a great tax benefit that you have by owning a property and passing it on to your children. It's a little bit lengthy of a concept. You can watch prior videos where I talked about the step up in basis tax ramification. Another one is basically the disqualification of the exclusion of gain of your house. So imagine a married couple. They have resided in a property or a home for 5 years. There's a $200,000 capital gain. They don't have to pay taxes off of that. But if you put it in an LLC and you did it wrong, then you're gonna have to pay the taxes off of that. So that's another reason why an LLC is not a good format. Number three, there is no homestead protection. So in California, for a married couple, I believe it's $125,000. Florida is unlimited. It's not a perfect asset protection tool, but it's an exemption that you felt to use because you put it in an LLC. The income tax deductions from property taxes and mortgage interest is something that you cannot take away when you put it in an LLC. And finally, a concept that is very true to California only is Proposition 13, the reassessment of property taxes from taking it from one owner to another. In this particular instance, in an LLC, again, if not done right, you can trigger a property tax that wasn't intended. So that was a mouthful, but you can tell I am not a fan of putting an home into an LLC, at least your primary residence. That's the tip for the day. You want to find out more? Visit us at www.assetprotectioncenter.com or call me 714-966-2646 and we'll talk about your situation. Thank you, and I will see you next time.